Welcome to another episode of Judgment Day. We've been dealing with a whole range of issues, mainly relating over quite some time now to the COVID pandemic in circumstances where I thought by now we'd probably be finished with this, but sadly we're not. But from time to time, we've been privileged to actually interview somebody on an issue which is slightly different, but I think to some extent comes out of the cauldron, a political cauldron, which has been basically precipitated by COVID-19. And one of the issues that certainly has affected us considerably over a period of time are incessant attacks recently on the judicial institution. And of course, that reflects upon what role it should play and what role it has played, and how to deal and understand with what is going on at the moment. There can't be anybody better in the country for me to interview in this than Justice Zak Yacoob, who has had an extraordinary career, a distinguished advocate, who did a range of cases, human rights cases, when it wasn't popular, in particular, as I recall, political cases in which the stakes were hugely high, and then rightly was elevated to the Constitutional Court, not initially when the court was created, but shortly thereafter. And anybody who now pages through the law reports will see a whole host of judgments that he has penned, which are crucial in the development of jurisprudence. So, Zak, thank you so much for joining us this morning.
Thank you, Dennis, for having me. I must actually emphasize your contribution to our democracy too, and your participation in unpopular cases.
That's very kind of you. Thank you. That doesn't mean I won't ask you hard questions. But I wonder whether I could start, Zak, but what do you actually make of what have become increasing attacks on the judiciary from a whole range of quarters? In other words, the judicial institution is not going through a very good time at the moment. So I'm interested in your take on it, what you make of that.
People who lose cases have for centuries criticized the judiciary. The way to defend yourself against cases that you've lost or unpleasant things that you have to do is to criticize the judges. So that is, in my view, nothing new. It has happened and will continue to happen. We thought that a constitutional provision, which we have already, would prevent that because it is constitutionally wrong to do so. It is unlawful to do so. But this is unlawful in many other countries. So that's the first point I wanted to make, that when the chips are down, the attacks on the judiciary are absolutely inevitable, and there is no way in which to avoid them. That being said, we need to look at causes, because at a political level, attacks against the judiciary happen very seldom. And it happens when political systems or political agendas are fighting for their survival. So people complain about judgments against them individually for paying a debt or something when they are fighting for their survival. At the moment, what is happening is that when political entities, political regimes, political agendas are fighting for their survival, then when you fight for survival, anything goes. And that is the basis on which the attacks on the judiciary are taking place. They ought to have been anticipated. It's not a particularly positive view, but it is something which we need to understand. And I think, let me wait for your next question.
Okay, well, my next question is, I mean, there have been, well, let me drill down. I mean, the Zondo Commission heard evidence. I'm not sure how reliable it is, and I have no idea about, various state funds that were used to influence results in favor of a certain faction. And there were allegations in that certain judges were on the take, as it were. Now, I suppose the question I have to ask you is, the public read this. Now, you and I may say, we've been on the bench cumulatively for 40 years. We haven't really seen this happen. We're happy with the institution. In fact, we're proud of the institution in the vast majority of cases. But the question, I suppose, is what does one do about these sort of allegations?
I think that one can't do too much about it unless one has evidence of exactly who it was. The temptation actually is to look at everybody over suspiciously, look at their judgments carefully and see how they are doing. But there's a problem because judgments are bad either because of inefficiency or because there's a particular agenda. Of course, there are exceptions. So, for example, I mean, as I said, it is not only political agendas that fight for their own survival, it is also judges. So in the context of wrong judgments, I have to say that Slope's judgment in relation to the deputy minister, the ex-deputy minister, is, as Johan Krichler said, deliberately wrong. There, Slope is fighting for his own survival, and I have no doubt that that judgment is not only wrong, but deliberately wrong. Everyone knows it's wrong. Nobody would even begin to suggest that it's right. It very seldom happens. But this is a question of 2 + 2 = 15 or something. It's as bad as all that. So the point is that even that wrong judgment, had it not been for the fact that he was fighting for his own survival, I would have put it at the level that he may have been on the take. But that is very difficult to do. And unless we have evidence, we just have to make sure that all our judgments are fine. And we have a system which is fine. If 1 or 2 judges are bribed, it's not going to make a huge difference. We have an appeal system. We have a broad constitutional court. And we have a good system because one must understand that most of the judges who give evidence, who give judgments, by the way, against Jacob Zuma now, are judges who are appointed by him. So ultimately, the fact that he appoints them makes no difference. And therefore, a bribe would make even less difference, actually.
But can I ask you this just about the Schlorpy case for one moment? I suppose here's the kind of counter argument is, all right, so, you know, you've had very strong words to say about it, and Judge Krichler had even stronger words to say about it in his statement. I suppose you and I, who both know Judge Krichler, know that's in typical Judge Krichler style.
Yeah.
But nobody can discount Judge Krichler's searing intellect in these matters. But would it not have been better, or is it not better, to hold one's fire about these cases and let it go on appeal and then evaluate it? In other words, once you've got situations, senior judges like yourself and Judge Krichler are making these public statements about Judge Schlorpy, whatever the merits of the criticism are, I don't want to get into that. My point is, doesn't that in itself undermine the public view of the judiciary? After all, we're dealing, as Judge Krichler said, with a hugely experienced judge president with a doctorate from Cambridge who's been on the bench for more than 25 years.
Ordinarily, that would be absolutely right. So ordinarily, one wouldn't comment on judgments, and I have not done so.
Yes.
There are, however, exceptions.
Okay.
And I think that this judgment is one of the exceptions. So I agree that ordinarily, one must have the discipline of keeping quiet about judgments until the appeal process is over. And secondly, it goes further because one must also have the discipline of accepting the correctness of majority judgments. But all those principles are subject to the exception that there comes a time when things are so bad that you are left with no choice. And I think that Schlorpy's judgment gets us there.
All right, so let me put this to you just to test the proposition. Yeah. So I'm listening to this program, And I happen to be a person, and I'm sure there are people listening to this program, who feel that Jacob Zuma has been hard done by. And and I'm one of these people who therefore have bought the narrative that Judge Zondo and other judges have got it in for my man, Jacob Zuma. And accordingly, I'm very critical of the judges. I listen to you and I say, well, that's really interesting. When a judgment goes in favor of a Zuma person like Bongo, then people are very sharp odds. But when they go against my man, then the judiciary is behaving in an independent fashion. The point I'm really making is how to actually get our way out of a situation whereby the judiciary is not always in the forefront of that kind of political controversy, or is the inevitability of it your point, that once you've got the sort of political difficulties you've got, the judiciary is always going to be in the firing line?
I think the judiciary is always going to be in the firing line, and I agree with you that the distinction is very difficult to draw between the kind of exception I postulate, which sounds particularly reasonable, and the kind of exception which if I was a supporter of Jacob Zuma, I would postulate. And the argument, and both that they are both sides of the coin, is quite strong. That he is the president of our country, he is a respected president of our country, he's been elected by the majority of the citizens, and the judgment against him is a judgment against the majority. Of course, you remember that there was a case in relation to Western Cape Proclamation by Nelson Mandela in 1995, which went to the Constitutional Court, and the Constitutional Court came to the conclusion that the regulations were out of order because it was the Parliament's duty, and therefore they should have been a legislative act and not regulation, and set aside the regulation passed by Madiba. In those days, things were very tough and complicated because everyone believed that Nelson Mandela was a hero. But I think you recall that that very night, he went on TV to say that the judgment of the Constitutional Court must be respected, and he absolutely agrees with it because he anticipated the problems that might arise out of the judgment of a Constitutional Court, which said that he was wrong. And he was exceptional at that level. The trouble is that you can't expect such exceptional conduct from many people. So yes, it is inevitable. And I think that there is a difference between the two exceptions, but the one can use the exception I use to support their exception, which is I think, something which is expected.
It's interesting you raised the issue of President Mandela. Of course, that was a really watershed moment. And I'm interested, just to probe that a little bit. If I recall correctly, you were certainly on the Constitutional Court bench when the Treatment Action Campaign case was heard and decided upon. I am right in that, am I not?
No, I was on leave.
Ah, you on leave? Okay. But I can still ask you this, because obviously being a member of that court,
yeah.
I mean, at that stage, I recall at some point the Minister of Health, who I think was Minister Shabalala, if I correctly, saying something, Mantu Shabalala Msimang, saying, you know, whatever the court may do, we're not really interested, and then being rebuked by the Minister of Justice, Penwell Maduna at the time, who affirmed the. So I suppose the question I was going to ask was, at that time, did the court feel an extent to which, if I put it this way, the Mandela era was over and they were all on their own, and that therefore they were reaching into a situation whereby they were going to bring controversy upon themselves? Or did people think at that time, actually, we were still living in a society in which government, even if there were a couple of eccentrics, were ultimately committed to the same project that Mr. Mandela was?
The majority of members of that court were of the view, and I was one of them, that court orders would be complied with, that one could give judgments against the government without too much of trouble. And I think that the first of those judgments was probably the Grootboom judgment in
Yes.
2000, which said that the government had failed to comply with housing policy. We were a little worried about the comebacks of that, but that had no comeback at all, because they didn't comply with the letter and spirit of the judgment, but they did pass the necessary regulations and so on to ensure that temporary shelters were available to many people. So once that was passed, I mean, it was at the time of the writing of Grootboom that we were really worried, because it was the first time that we were stepping into the socio-economic terrain, and we were saying that government decisions were wrong. We were a little hesitant about doing so, but we had to do it, and we did it. And I think that the fact that the government didn't moan too much about that judgment helped a great deal. And in those days, one used to meet ministers in airports and so on. And I met many a government minister after Grootboom had been written who said, yes, man, they'd comply with it. And they were very praising of it. So it was a different time.
And I want to talk about that different time in a moment. But before I get there, one final question on the judiciary, on the topics that we've been talking about. There has been a lot of comment recently in the press, and I don't want you necessarily for you to go into the merits of the cases, but here's the public perception, that there was a complaint against Chief Justice Mogoeng, which was dealt with very expeditiously. And there've been a series of complaints against Judge President Hlophe, which seemed to be drag on forever and a day. And people are saying, why on earth is this occurring? What is happening here? And there've been suggestions that some judges are immune from accountability and others aren't. And I suppose the real question comes down to the heart of the evaluation of the Judicial Service Commission as the mechanism to hold judges accountable.
Yes, I actually think that in relation to Mogoeng, I was trying to think of the reason why this happened so quickly. But I think that when you're dealing with your own, you have got to deal with it quickly. So Mogoeng was the Chief Justice. He was also the boss of the Judicial Services Commission. And that's why, in a sense, the JSC was dealing with a complaint against itself. I know that Hlophe also served on the JSC, but in a different capacity. So I think, generally speaking, the machinery of the JSC is slow. What happened to Hlophe is a reflection of the general machinery of the JSC. I don't think anybody was holding back really and taking things easy. It was the machinery which didn't work. It was experimental. It happened for the first time. But here, because the Judicial Services Commission was looking at itself in a way, and its own boss in a way, and its own credibility, it had to do it quickly. I think that was the reason.
And are you, I mean, there've been a lot of criticism about the JSC as the mechanism to deal with this. I mean, do you think that we should be reflecting upon changes to the JSC, or do you think that the JSC, in very difficult circumstances, is doing about as well as we could hope for?
I think that the JSC could change somewhat, could do its work a lot more quickly. But remember that in Hlophe, part of the problem was that we have the system of justice, which is too forgiving and too flexible, ultimately, so that anybody who has a judgment against him can take it on review. Let's look at Mogoeng's case before the JSC. He has a month to appeal. If I were him, I would not appeal a single day before the expiry of that month. I would probably apply for condemnation, saying I was ill or something and couldn't do it until 2 weeks after the expiry of the month. Then you do everything slowly and carefully. And by October, he would have retired as Chief Justice, and the whole trouble will be over. So there's an appeal against that decision, and then you review that decision in the High Court to start with, go slowly through the Supreme Court of Appeal and to the Constitutional Court. So anybody who wants to can abuse our judicial system and go at it for 4 or 5 years. The answer to that is that the judicial system has to become much, much quicker at what it does. So if an appeal like this is resolved in a couple of weeks, and if the High Court hears the matter quite quickly and delivers judgment quickly, then it's fine. But the problem is that judging does take time, as you know.
But I know it takes time, but I suppose the point that you raise, which is an interesting one, is that it has been suggested that certain courts, perhaps all courts, are very, as you say, forgiving, to use your term, and therefore are wont to grant leave to appeal, or on petition, the higher courts basically allowed to occur in no-hoper cases. And that this allows that famous statement of the Stalingrad defense to continue ad nauseum. I mean, if you take Britain, for example, it's quite difficult to get leave to appeal to the Court of Appeal, and particularly difficult to get it to the Supreme Court. Aren't we just sort of playing into the hands of people who want to postpone by actually not being more careful in relation to granting leave, particularly when it's obvious that there is really no merit in the matter?
Well, it's difficult to know when there's really no merit. For example, we had a rule in the Constitutional Court that if one judge out of 11 feels very strongly that the case should be heard, we would hear it. And there was an election case in which one judge, not me, felt strongly and 10 judges didn't, where a municipality or a political party had not paid its deposit according to the commission for participating in elections in a particular area. And the IEC had refused registration. They were appealing against the registration. And all of us, from the information available at that time, said, there is no chance. And one judge said there was. And finally, the appeal succeeded 10-1 on the very interesting basis, which hadn't fully come to light, that the political party concerned had paid a deposit before the election started, and that the amount to the credit of that political party exceeded the amount it owed in relation to the fees for registration for that particular election. And then there were a case which was set down on the basis that 1 out of 10 out of 11 wanted it set down, succeeded on the basis that 10 out of 11 judges voted. So in a way, there are advantages to being very careful about refusing leave to appeal in a final court, because there can be success sometimes.
Point made. I take the point, but of course the question about how we expedite these disputes is an important question. I also
absolutely. I think things could happen much more quickly than they do.
Yeah. So then I want to just move back to a comment that you made and focus on it when you spoke about the TAC case being a different time. And I wonder, bearing in mind that the constitutional project was based on the idea of developing a non-racial, non-sexist, non-homophobic society, raising the dignity of 60 million people, I wonder whether it's not so that we've drifted quite far away from that, and that the environment today in the year 2021 is very, very different from what it was when there was such hope under the Mandela era, and maybe even in the early years of the Mbeki era. Do you think we are in a worse space? And if we are, how do we get out of it?
I think we are in a very, very bad space politically. And that is because the country has become basically corrupt. And I think that the only way out of it is to rid ourselves of corruption and to start developing a new culture. It's a very long process, But until such time that we start from scratch and make sure that we start ensuring that people believe in integrity and honesty rather than in financial enrichment, it's going to be a very, very difficult road forward. I think part of the problem is that the world has become more materialistic too, so that money has become an important factor. I mean, I said, for example, that I wouldn't charge any money for some work that I did for, well, I don't charge any money for work that I do for organizations nowadays. And most people are unhappy about it because they say, well, I must charge the money and make sure that I donate it to some charity. In fact, some of my judge colleagues have been to me to say I spoil the market by not charging. But people don't understand that sometimes enough money is enough money and you don't need more. And it's important for us to do things to make society better. And I think that until and unless we develop that culture of non-materialism, our problems would continue. And I think that they are world problems. They happen a bit more in the background in the Western countries, in a more sophisticated way, in a more hidden way. They come out in rumors from time to time. But I think that in all materialistic societies, that is going to be the problem.
But don't you think in the South African context that sadly, for whatever reasons, we could debate those, that for very, very millions of people who are referred to as historically disadvantaged, they remain presently disadvantaged. And until such time as we flip that, we are going to be in a society of considerable racial turbulence, because it does happen that race and class overlap in the way it does, and people have not got better off. In fact, to the contrary.
That is absolutely right. I think that when you have been poor, as all of us have been, and when you become okay, there are two approaches, and most people have a feeling of entitlement, and some people are grateful. It is true that let me just say this. I know that most of the people who went to Parliament in 1994 had no money at all. And I know from personal experience that all of them thought that the amount of money they were going to earn was a lot of money. People began to exploit this, and you go to Parliament any day in Cape Town in those days, you will find it being marauded by insurance agents and cell phone salespeople and all sorts of things. And before the MPs knew it, they were over their heads in debt because they thought they had a lot of money and they didn't have a lot of money. And you get yourself into trouble in that way. The other problem is that if I were earning 15,000 a month somewhere and my mother got sick and had to go into hospital, the public hospital system is so bad that I would want her to go to a private hospital, couldn't afford a private hospital. And therefore, if I were working in a pension office and I could charge 1,000 Rand to get somebody a pension, and that helped me to get my mother into hospital, it would be useful. So I think that the bad health system gives rise to corruption in an odd way. The bad education system gives rise to corruption too, because many people who are in government service steal so as to ensure that their children are able to go to private school, and they justify it in that fashion. So unless we get the corruption sorted, unless we get the education system right, the health system right, and develop a new culture, I think we're going to be there for a very long time.
And how optimistic are you about that?
I think it's going to be a long way.
Let me introduce a personal add to this. I started reminding you that you and I had been debating Lenin and Trotsky in 1982.
Yes.
When I look at it, about almost 40 years ago. I'm not sure that if we had spoken then, we would have conceived of the fact that you would have been on the Constitutional Court and had a hugely distinguished career there, and even I would have made the High Court level.
Yes.
I suppose there is always room for not quite knowing what the future holds. But the point I'm simply making is, in the light of that and what we've lived through, how hopeful are you that we will negotiate these difficulties and, in a sense, re-establish the strength of our constitutional democracy?
We certainly will. And I think it's a societal question. And if you look at society in very general philosophical terms over the last 200 or 300 years, things have gone up and down. Things have gone in different directions in 50, 60-year cycles, I suppose, from conservatism to radicalism and so on and so on. So things change, may take time, but I think that time will come. In 1982, Dennis, you and I would find it very difficult to find a lawyer who was against the death penalty. Today, you get them by the dozen, don't you?
Yeah. I have to hold on to that, I suppose, Zach. But I suppose my final question to you is that when I read some of the statements made by politicians today, it worries me that that kind of embrace of constitutional democracy, which we felt was transformative and was going to allow us to negotiate a road to a society in which, as I say, the historically disadvantaged would no longer be disadvantaged. I just wonder whether, in fact, thanks to what's happened over the last number of years, there is that same commitment to that model as there was when you first were elevated to the Constitutional Court, or indeed me to the High Court.
I don't think there is that degree of commitment, and it shows in many ways. Because if you look at our presidential addresses, in the first 2 or 3 of them, the Constitution was always mentioned. And thereafter, the Constitution is not referred to in political speeches, budget speeches, the president's speeches, or anything, anywhere, or in determining policy. And yet, one would expect all government departments and everybody involved to take the Constitution as a starting point in the development of their policy. The Constitution has to be, and the values of our Constitution has to be the beginning, the middle, and the end of policy formulation. Now, it was never like that, but in the first 10 years of our democracy, more or less, the Constitution did play some role in policy formulation, though not enough. And yet, and after that, its relevance have become less and less. We have chapter 12 of our Constitution which deals with the public service. I've spoken to a number of senior people in the public service in the last 10 years, and they've never heard of chapter 12. One would imagine that anyone who joins the public service ought to be made aware of the provisions of the public service in the Constitution, so that they comply with the constitutional obligations. But the problem is that the Constitution itself has been relegated to the background.
Yeah, it's an important point, and I've run out of time because I'd like to debate that further, because it's interesting just to make the comment that Michael Sachs, who's a very distinguished member of the Treasury and now I think is a professor, made the point that the budget today doesn't in fact comport with the constitutional commitments that the governments owe the country, which is an interesting debate that we should be having, is what is the role of the Constitution in the formulation of policy.
Absolutely.
I'll leave it there so that people can debate that, because I've run out of time. Zak, as always, forthright and clear and certainly illuminating. Thank you so much for giving us your time and giving us a perspective of where we are in the constitutional democratic road. Again, thanks a lot.
Thank you. It's good to be here. Thank you very much.